Good afternoon, everyone. Thank you so much for joining us today for our discussion about professional malpractice prevention. If you have attended any UToledo alumni events in the past, you may not recognize me. My name is Amanda Kegg. I am the new Assistant Director of Alumni Engagement for the University of Toledo Alumni Association. I began working back at the end of March, and so I'm very excited to maybe meet all of you in future events in person, hopefully. I'm not a new person to the Rocket family. I graduated back in 2008 from the Neff College of Business and Innovation. So again, I'm very happy to be here. Looking forward to meeting all of you, like I mentioned, in person in future events. Today for our presentation, we will be joined with Mr. James Tuschman. He is the Director of Outreach and Engagement for the University of Toledo College of Health and Human Services. I think he will have so much great experience and background on this topic. I'm really hoping you'll be able to take some things away today and use them in your professional career. As guests continue to join us today, I'd like to share just a few housekeeping notes. Attendee names are not visible to other attendees, and you'll only be able to see your name on the attendee list. So don't worry, there are many alums joining us today for today's presentation. And hopefully at the end of James's speech, we'll be able to kind of connect and network at the end. And if we have any questions throughout the presentation or at the end, use the chat box and we'll make sure to get to those. So without further ado, I'm going to go ahead and turn it over to Jim.
Do you want the dean to talk first, Amanda, or do you want me to talk?
Oh, I'm sorry. I don't, oh, I'm sorry, Mark. I didn't see that you had joined.
No worries, Amanda.
No
I'm happy to chime in here.
I have to let my dean go
I'm so sorry
first.
about that.
Oh, no worries. So thank you everyone for joining us this afternoon and giving us a little bit of your time during lunch. It's always a pleasure to be able to connect with our alumni and our stakeholders. It's my pleasure as the Dean of the College to introduce Jim Tuschman. Jim is a member of our faculty with a long and distinguished service career to the university, the community, and the state. Jim's a former member of our Board of Trustees. Jim is a former regent with the Ohio Board of Regents. And Jim now serves us with a lot of instruction in our paralegal and legal services programs. And Jim's presenting to you today from right here in our school. You may not recognize the courtroom if you haven't been in those programs, but the McQuaid courtroom is a specialty classroom that we have in the building. And it's a great place for Jim to present on this particular topic because Jim brings a lot of experience as an attorney, spent a lot of time in courtrooms, and he brings specific expertise related to medical malpractice. So it's a pleasure to introduce Jim and let him bend your ear for a little while on this topic that I think we'd all like to hear about. So Jim, take it away.
Mark, thank you. Thank you very much, Mark. Welcome, everybody. Good afternoon. It's a pleasure to be here. So today we're going to talk a little bit about a prescription for the prevention of medical professional liability. The problem is that injuries due to medical malpractice are unfortunately the third leading causes of death in the United States after cancer and heart disease. That's pretty amazing. Now, these lawsuits, medical malpractice lawsuits, take the form of a themed narrative that is persuasive and compelling and usually involves very serious injuries and sometimes even death. And if that wasn't the fact, then they most probably wouldn't wind up in a courtroom like this. Now, I wasn't really planning on mentioning something that I am about to talk about because it happened last night. Last night, my son, who is a trial lawyer in Northwest Ohio, state of Ohio, obviously, a very experienced medical trial lawyer, is a plaintiff's lawyer, rated one of the top plaintiff's lawyers in the state, was in a medical malpractice case. It was a birth trauma case. And last night, the jury came back with a $10.2 million verdict against a small County Hospital in Northwest Ohio. And the reason I mention that, obviously very proud of my son's work, but I mention it because I had a chance to look at this case some time ago. The case has actually been worked on for the last 6 years. And it exemplified some of the worst mistakes made in handling a medical malpractice case by the health professionals. And so I'm going to talk a little bit about that and a case that I actually handled for the plaintiff, which is unusual for me because most of my career was a defense lawyer, to point out some of the issues that I would like you all to be familiar with in hopes that you can use this information to help avoid sitting in a courtroom where a jury returns some huge verdict against a healthcare provider. Family members whose loved ones have been injured due to a medical error can pursue compensation in a medical malpractice case for lost wages, for damages, for pain and suffering, for all sorts of issues, and particularly when there has been a death of a family breadwinner. These cases can take on huge, they can amount to huge potential in the courtroom. One of the most common reasons for filing medical malpractice claim is for errors of misdiagnosis and delayed diagnosis. My son's case was a situation of a delayed diagnosis by a nurse midwife who basically was ignoring evidence on a fetal monitor that a fetus was undergoing horrific perinatal asphyxia. That is, essentially, the fetus was undergoing lack of oxygen and needed to be delivered immediately. The nurse unfortunately sat on this situation for 2 hours, and when the baby was eventually born, it was born essentially compromised and then immediately died. Now, these claims, these medical malpractice claims, are usually handled by very experienced trial lawyers who are experts in medicine and who can evaluate whether a malpractice claim exists or not. Those of us who have been in this practice have experienced years and years of medical training so that we can deal with these types of medical issues. You can't really defend a doctor or hospital unless you are proficient in medicine, and you can't really prosecute a case unless you're proficient in medicine. So the lawyers that you face in these cases, either as a defense lawyer or as a plaintiff's lawyer, have extensive experience in the medical field. Well, the question is always, why are there so many lawsuits in the medical field as opposed to any other profession? And the answer really is sort of simple when you think about it. Medicine is the only profession that has a daily diary of its events recorded. And this gives lawyers, both on the plaintiff side and the defense side, an opportunity to scrutinize that record, that diary of events, and look for errors, or if you're on the defense side, look for matters that will support the care, treatment, and medical management of the patient. So what is medical malpractice? Medical malpractice occurs when a doctor, hospital, or other healthcare professional injures a patient, neglecting to follow the recognized standard of care and that neglect directly and proximately causes injuries and or death to the patient. So let me share a screen with you and perhaps show you schematically what I'm talking about here. On the screen before you is a diagram that I use for my students. And this diagram basically is a wiring diagram. It shows a battery, it shows 4 switches and a light bulb. And the key to proving a medical malpractice case is to prove the 4 elements necessary to establish the case. And those elements are represented by the 4 switches in this wiring diagram. The first switch is that of duty. There must be a recognized duty of care. Secondly, there must be a deviation from that recognized duty of care. That third, directly and proximately causes. Fourth, damages and/or death to the patient. So before you can prove as a plaintiff's lawyer the elements of medical malpractice, you have to establish what I call the 4 Ds: duty, deviation from that duty, direct causation, and damage. So how do you do that? Well, that power source that I have put in the diagram is the expert witness. The expert witness has to opine on each of those elements. The expert witness has to say there is a recognized duty of care, that the healthcare provider deviated from, that directly and proximately linked to the death or damages of the patient. Now, that third element, called direct causation, is a very, very important factor, because it indicates that to prove a medical malpractice case, you must show an unbroken cause and effect link. So whatever the doctor did or failed to do, or the healthcare provider did or failed to do, there must be an unbroken link of from cause to effect. If there is an intervening cause, such as perhaps the patient's underlying medical condition that was not exacerbated by the deviation from the standard of care, then the chain of causation is broken and the plaintiff does not substantiate or prove his or her case. When all those 4 elements are established by an expert witness or expert witnesses, then you've completed the circuit, the power runs through, and you light the light bulb of liability. You have proven your case. It's then up to the defense to find ways in which they can bring in evidence that would negate some of the proof established by the plaintiff or through the plaintiff's attorney. So that essentially is a schematic way to look at the standard, way in which we lawyers go about establishing medical negligence. So let me define for you the terms in a little more detail. I talked about duty, the obligation owed to use due care in the care, treatment, and medical management of a patient. Deviation means a violation of the recognized standard of care. The standard is what a reasonable healthcare professional would do under the same or similar circumstances. And then direct causation is a link, an unbroken chain of events from cause to effect. And the damages, of course, have to be substantial or the case is never going to wind up in court. This can be an injury to the patient where the patient suffers a disability, a loss of earnings, a loss of earning capacity, a loss of significant past or future earnings, pain and suffering, and even death. These are the elements of damage that we deal with as malpractice lawyers. So the question, as I said, is how do you prove these elements? And as I pointed out, this is done through the use of expert witnesses. And these expert witnesses have to come in and testify to the elements of duty, deviation, direct causation, and damage. And they have to establish the case by what we call in the law a preponderance of the evidence. Now, you've heard about criminal law and you hear about beyond a reasonable doubt. That has nothing to do with malpractice. When we talk about preponderance of the evidence, what we're talking about is the proverbial scales of justice. You've seen the scales of justice with the scale basically in balance. Preponderance of the evidence means that you, the party going forward, the plaintiff, have to tip that scale slightly in your favor, not completely, but slightly, 51%. If you can establish by the quality, not the weight, by the quality, not the quantity of the evidence, then you have sustained your burden of proof and established your issue by a preponderance of the evidence. If any of those elements, of those 4 elements I talked about, are not established by a preponderance of the evidence, the claim fails, the defense prevails. What then are the common forms of malpractice lawsuits? Well, here they are. Misdiagnosis is probably the first. Delayed diagnosis. Healthcare acquired infections. Childbirth injuries. I just talked to you about that. My son was just involved in that. Medical errors and surgical errors. Those are probably the common forms of malpractice. I'm going to talk to you in a few minutes about a case that I handled involving some very serious medical errors. Well, what then is the prescription that I want to offer to you for the prevention of these professional liability lawsuits? Well, time doesn't permit me to go into great detail, but I'm going to review them in a brief detail. And then hopefully if you have any questions later, I can try to expand on them. First, it all starts with the medical record. The medical record in malpractice is Exhibit A. Every malpractice case starts with the medical records, that daily diary of the events that took place in the case. We lawyers scrutinize those documents. That's why we have to be medically trained to understand what's there. We obviously have help, expert witnesses, nurse paralegals, all sorts of auxiliary help. But at the end of the day, the trial lawyer who's responsible for the case has to have a very, very good understanding and comprehension of the medical issues. The medical record can be a sword or a shield. In the hands of the plaintiff's lawyer looking at medical records that are damaging to the healthcare provider, it's a sword. In the hands of the defense lawyer, a well-documented and well-articulated medical record is a shield. This daily diary is scrutinized by lawyers, and this diary must be legible, it must be unaltered, it must evidence a clear plan for the care, treatment, and medical management of the patient, and it must evidence all exams, procedures, and counseling. I have had in my career a situation where I had to defend several doctors who had unfortunately altered their medical records, and it became an extremely difficult case to deal with because of the altered record. I also had a chance in several cases to pursue as a plaintiff's lawyer 2 doctors that altered records, and I was on the other side of that event, and I can tell you that they, the deposition that I took of them, catching them altering the records was not very pleasant for them. Nurses' notes. Nurses' notes are what we lawyers say, that's where the goodies are. Nurses' notes can be very helpful or very harmful depending upon what is in them. Many times lawyers will scrutinize and look at the medical record and see the doctor's progress notes saying one thing and the nurse's notes going in an opposite direction. Bad news for the healthcare providers. There must be consistency, but nurses are very good charters, and they usually diary a lot of what is going on, including how the patient is reacting, how the patient feels, what the patient is saying. So nurses' notes become a very important aspect in the scrutiny of medical records in medical malpractice cases. And as I said, these medical records are really Exhibit A in a malpractice case. So let me talk to you about some of the other issues of prevention. Avoid poor follow-up, a critical factor in medical malpractice cases. Doctors commence a diagnosis and then their follow-up is not good or not properly documented. Next, build functional, trusting relationships with your patients. I can tell you of instances where we were representing physicians and or hospital personnel, where when we took the depositions of those who are charging them with malpractice and poor care, really were advocating that were advocating in their depositions that they really had no rapport or any relationships with the healthcare providers, and that they really were very uncomfortable with the way they were treated. So building functional and trusting relationships with your patients is an important factor. Always maintain patient confidentiality. Guard against missed or delayed diagnosis. Offer honest apologies for any mistakes. I can tell you that if my son's case that I just talked to you about, case is 6 years old before it went to trial. They've been working on it for 6 years. I can assert to you, because he had told me, that had that hospital and its personnel come forward and say, look, there were some serious management problems here, but we need to sit down and try to resolve this case. We understand we made some mistakes. Chances are this case could have been resolved at a number much, much less than what the jury came up with last night. Offer honest apologies for any mistakes. Now, you don't do that without talking to your insurance company or your insurance company lawyer. You don't do this on your own, but you get counsel. But there's nothing wrong if a mistake was made to sitting down with your lawyers, your insurance counsel, and dealing with those mistakes. Believe me, it can make a difference. Obtain medical malpractice insurance. Obviously, most of you have to have that to get work in any healthcare institution. Make sure you have a highly experienced defense lawyer. Those of us who are defense lawyers, as I say, have to be really schooled in medicine. You want to make sure that you have someone with extensive experience. These are serious cases. And as I just told you, my son got a $10.2 million verdict. That's serious stuff for a hospital or a physician or whatever. So you have to make sure that the insurance company that you're represented by is providing you with an experienced lawyer. And there's nothing wrong with asking that lawyer, tell me about your cases. Tell me about how many cases you've tried. Tell me about your medical background. Tell me about your experience. Nothing wrong with that. Develop and maintain good communication with your patients. Don't be afraid to refer to a specialist if you feel as a medical professional that you need help. Nothing wrong with that, not a sign of weakness. Be clear and consistent in your dealings with the patient. And always get informed consent. You have to explain the risks, perils, options, and hazards of a procedure. That's required by the law. Something that many healthcare professionals do not do is this. The informer must be the performer. The informer must be the performer. The law requires that the person that provides the risk benefit information has to be the person that's doing the procedure. I will tell you many healthcare providers do not follow that rule. But if you get caught and you're in court and the person that provided the information wasn't the person performing the test or the procedure, you got problems. The informer has to be the performer. Always memorialize your conversation. If you do have conversations with patients, and you obviously have informed consent forms, but if the informed consent form is not being used, or if you use it and you have more conversation than just having the patient sign the informed consent form, memorialize the conversation. Write some notes in the chart. And a lot of times I'll tell physicians, after you've talked to the patient, have the patient initial what you've just written down. There's nothing wrong with that. That indicates that that conversation actually took place. Many times you're going to get patients to get on the witness stand and say, I don't remember that conversation. And some of that may be true because they're under stress, they're having pain, they're in a very stressful situation. They may not remember. But it's important if they challenge your disclosure of material information, it's important that you are able to establish that you actually provided it. So stay current in your fields and your specialty. There's nothing worse than a healthcare professional who really is not up to date on things. When I talk about this case in a few minutes that I handled, you will see that one of the nurses in the case that provided some medicine didn't understand what she was doing and was not up to date on some information. Always, always be prepared when you are dealing with a patient. Follow proper and recognized procedures, understand the medicines you prescribe and that you treat with. If you don't understand them, look them up. Because at the end of the day, if you prescribe it, you're responsible. Give the patient time. Answer the patient's questions. Many times we will talk, and when we take depositions of patients who have sued their doctors, and I take depositions of these patients, one of the things they say is, we brought the lawsuit because nobody would explain to us what happened here. How did this happen? How did my husband die? How did my husband lose a leg? Nobody explained this to us. Give the patient time. Answer their questions. And I know that healthcare professionals, like every other professional, time management is a challenge. But to do this right, you've got to give them time. Listen to the patient when taking a history. Many times that history will provide you as a healthcare professional and as a diagnostician of critical information you need to deal with their care treatment and medical management. If you are sued, be a partner with your defense lawyer. Those of us who have to defend doctors and hospitals can't do it alone. We need the client to be working with us as our partner, as someone who can help us and help us sort through the myriad of information that we have to deal with. Be a partner with your defense lawyer. Just throwing it onto his or her shoulders isn't the answer. This is your profession that's being challenged. This is your case, and you need to be a partner in your medical malpractice professional liability matter. Understand that if you are sued, you're a stranger in a world that is an entirely different culture. I tell clients that when they walk through the double doors of a courtroom, they are no longer in the godlike, they're not treated in the godlike way they are in the hospital setting. They are in an entirely different world. They're in our world, in lawyers' world. They're being looked at, scrutinized by jurors and judges and others and other lawyers. They have to display an attitude in that public forum that is not something that will hurt them in the long run. And we lawyers try to work with them on how they handle themselves in that different setting, the legal setting. So when we dissect the causes of these many lawsuits, we find some very common repeating factors. One, patients are looking for answers on what happened. Out of fear, the medical professional may limit or even cut off communication. That's a mistake. Two, the rapid growth of technology and diagnostics has generated lawsuits because the medical profession is able to look at and see things today that they never could even imagine seeing into the human body, with MRIs and all of the amazing technology we have today for diagnostics. But it, in a sense, also enables others to look at things and say, you know, there probably is some mistakes made here. We also see experts' willingness to testify. When I first started practicing many, many years ago, plaintiffs' lawyers, I was a defense lawyer, but plaintiffs' lawyers had a hard time getting experts, not today. Plaintiffs' lawyers can go to expert referral services and get experts of any kind, any specialty. So this enables malpractice cases to go forward. The change in the physician-patient relationship has been a factor. No longer is the family physician the friend of the family, because now we have specialists and hospitalists and consultants, and the relationships that patients have with their doctors has changed. It's much more impersonal today. Many doctors are now employees of health systems. They're not the private practitioners they used to be. Easier for patients to go against these hospitals and their employees than it would be a longtime family doctor or someone that they've had a long-term relationship with. So let me take you, for the few minutes that I have left, let me take you into a courtroom like the one I'm in right now, and for a few minutes show you what a malpractice case can look like. The case I'm going to talk to you about is a case that I handled for a family that lost a child who went into a hospital for a tonsillectomy. She was 2.5 years old. She was the only child of this family. A lawyer friend of mine who happened to be a professor of law here at the University of Toledo knew the family. And he asked me if I would look into the case. Now, I'm a defense lawyer, and normally I don't handle these types of cases. But I said, yes, I would take a look at the case, and I did. And I took in a colleague who was a plaintiff's lawyer who I actually had spent different cases in a courtroom against, but a lawyer I respected, a lawyer I knew was a good plaintiff's lawyer, and I thought, because I was sort of doing work that I normally did not do, plaintiff's personal injury, medical malpractice work, I thought I'd take in a colleague to take a look at this case with me. We got the medical records, we hired experts, we studied the care, treatment, and medical management. We concluded that the nurses in this case mixed up 2 significant medications that basically caused this child to go into a respiratory arrest and die. Briefly, the case was as follows. A 2.5-year-old child was admitted to a hospital here in Northwest Ohio. It was a small hospital, and the child was there for a tonsillectomy. The child had the tonsillectomy, and as the child was going to surgery, the parents, she wanted to walk instead of being wheeled, walk down the hall with the anesthesiologist and the doctor. And the parents called her name. Her name was Bailey, and said, Bailey. Bailey turned around, waved to her parents as she walked down the hall to her tonsillectomy. After the tonsillectomy, she returned to the floor. Now, normally she would go to a pediatric floor, but this hospital and the day in question didn't have enough children for the pediatric ward, and so they put this child on an adult floor. And when the child complained of being nauseous, the doctor in charge, the surgeon, ordered a suppository of a drug called Phenergan and ordered a pediatric suppository of 12.5 milligrams. The nurse in the case, who was on the adult floor, later in deposition told me that she never knew that there was a pediatric dose of Phenergan, and so went to the medicine cabinet and took a suppository that unfortunately was 50 milligrams of Phenergan and gave it to the child. Shortly thereafter, the child was also experiencing pain. And so the doctor ordered a very low dose of morphine. Then another nurse came along and made a mistake and gave the child Dilaudid, which is a powerful painkiller used in cancer patients. It is 8 times the strength of morphine. And so now this child had an adult dose of phenergan and now an adult and a dose of Dilaudid, an adult narcotic, 8 times the strength of morphine. How did they discover all this? Well, we discovered when we went into the records that the medicine count for morphine that day had 1 extra morphine available and 1 less Dilaudid. And we realized what had happened here. What happened to the child was that the child went into a respiratory arrest and died in her mother's arms. We filed suit against the hospital for wrongful death. The hospital hired a major defense firm. They eventually offered us $500,000, which we turned down. The trial took a week. I called numerous witnesses, one of which was the nurse who mixed up the phenergan. And briefly, what I did is I took a bag of suppositories that had different quantities, different strengths, including a couple that had 12.5, one that had 50, and there's also a middle range. I put them in a bag and handed it to the nurse witness, and I said, "Nurse, I want you to reach in that bag, and I want you to hand me the pediatric dose of phenergan, please." And so she rumbled through the bag, looked at things, and a few seconds later pulled out, reached out, and handed me suppository. And I said, "I don't want it." "How do you know it's a pediatric suppository?" She said, "Well, it says here right on the label." I said, "How long did it take you to figure that out?" She said, "Well, I don't know, a second." I looked at it. I said, "Nurse, if you had taken that second, in this case, we wouldn't be here today, would we? This girl would be alive today, wouldn't she?" She broke down, she cried. And she also admitted that she didn't know that phenergan came in a pediatric dose. I later called the president of the hospital and briefly put up in large boards in the courtroom the mission statement of the hospital. And I took the president of the hospital through that mission statement. "What's a mission statement, Madam President?" And she said, "Well, this is what we hold ourselves out for the public, what we are as a hospital." And I went through those items, and she acknowledged that every one of those items on the mission statement were violated in this case, and concluded at the end that basically they had failed miserably, which became the headline in the newspaper the next morning. So it came time for a closing argument, and I gave the closing argument. At the end of that closing argument, I said this, and this is the point I want to leave you with. I told the jury that we're here today because a little girl is not here. And she's not here because of the carelessness of this hospital and some of its employees. And I said, what's missing here is a little girl. In trying to tell you, ladies and gentlemen of the jury, about a little girl, I'm reminded of some words that I read once that describe a little girl. And I offered this reading. Little girls are the nicest things that happen to people. They're born with a little bit of angel shine about them, and though it wears thin sometimes, there's always enough left to lasso your heart. A girl is innocence playing in the mud, beauty standing on its head, and motherhood dragging a doll by the foot. She's the loudest when you're thinking, the prettiest when she has provoked you, the busiest at bedtime, the quietest when you want to show her off, and the most flirtatious when she absolutely must not get the best of you again. She can muss up your home, your hair, your dignity, spend your money, your time, your temper, but then just when your patience is ready to crack, her sunshine peeks through and you've lost again. When your dreams tumble down and the world is a mess, It seems you're pretty much of a fool after all, because she can make you a king when she climbs up on your knee and she whispers, I love you best of all. And as I did that, behind me was a screen that we had erected. And on that screen, see if I can pull it up. I'm not sure I can. On that screen was the picture of Bailey waving to her parents as she walked down the corridor to her surgery. The jury retired after the defense lawyers, let me get back here. The jury retired after the defense lawyers' closing argument. And within an hour and a half, the jury returned the 10th largest malpractice verdict that year in the state of Ohio. And probably malpractice cases have consequences because both nurses were fired, the president of the hospital resigned, and fortunately, little Bailey's mother, 2 years later, gave birth to a healthy little girl who now is approximately 20-some years old. So that is my thoughts for you today on the prevention of medical malpractice. Dean, back to you.
Thanks, Jim. You know, as I reflect on that, and I've had an opportunity to be an expert witness in a couple of cases along the way, and I think you made a really good point earlier about the importance of disclosing and apologizing and being upfront and clear and transparent. And I've had an opportunity to do a little work along the way with a nonprofit group called Sorry Works, which has some tools that might be helpful to folks in how to go about doing that. So I just put that up in the chat as a link for anybody who's interested in some tools maybe about how do you go approaching that. So you may find that helpful. But I wanted to thank you for your presentation. I found it thought-provoking, and it certainly captured some of my own experiences from having been a witness in a couple of cases. And I think there's a lot of things here that we can avoid stepping in along the way that would really help us out. And I think that this was helpful in pointing a few of those out. So thank you.
All right. Yes, thank you, Jim. We do have some questions that came in, and I thought I would ask you a couple of those and see if anyone else has any. Please submit those to the chat box.
Sure.
The first one is, how do you foresee COVID malpractice cases being allowed or handled in the near future?
Well, that's a good question. First of all, I should start by indicating that the courts across the United States, with very few exceptions, interesting, my son's case being one of them, are still pretty much shut down. So we're not going to see a lot of litigation here for a little while until these courts really become comfortable in opening up, bringing jurors in, bringing court personnel back in. In terms of the issues of COVID, I'd be interested in knowing what the questioner is talking about. If they're talking about reactions to medications such as the various vaccinations, I think the government has pretty much set up instances where these drug companies are being held harmless because they had to rush out these vaccines. So I'd have to think through where these deviations from standard of care may come about. I happen to have a good friend of mine who was a physician who I was talking with about 3 or 4 weeks ago, and as a good friend of mine, he went in for his shot, and they gave him his shot, but they gave it to him in his arm, but much higher than in the deltoid muscle, I think, where it's supposed to be. and his arm blew up. He couldn't use his arm for a couple of weeks. And he was a doctor that needed the use of his arm. And there was questionable mismanagement of where they placed the shot. He's not going to do anything about it, but it could have been worse. He was in agony for weeks as a result of this medicine going into the wrong place. Do they have any specific issues on COVID they would like me to talk about?
I don't see any. I think it was just more of a generalized question about maybe.
I would say generally, I don't think we're going to see a lot of malpractice in the COVID area. I think the government has stepped in to pretty much insulate the care, treatment, and management in this area, because remember, we got all these vaccines that normally would take years. We got them out in record time, and they appear to be pretty effective. So I would say, with limited exception, probably not a lot.
That wasn't I don't know, can you hear?
Yeah, I can hear
Yeah,
you.
That was not, I wasn't saying anything about the vaccines. I'm referring to like patients that were in ICUs where I'm a nurse and they were so understaffed, and I could say, no offense to you as a lawyer, but I could see these lawyers coming to attack every nurse, every doctor who was doing their damn to save these patients. And we didn't have the staff, we didn't have this. So I hope the government stops you guys from doing this, because when you're doing everything you can and it's still wrong because you don't have the staff and you're getting sued and your license is going to be taken away because somebody's loved one died, who probably had diabetes, was overweight, or everything else combined, and then they're going to come and attack the nurses and the doctors to sue us for their wrongful death, quote unquote. That's what I was referring to.
Karen, that's a great question. Let me try to respond to that briefly. First of all, people like you are godsends. I know how much the nurses of our community and across the country, nurses, physicians, healthcare providers, stepped in at the risk of their own lives to save the lives of their fellow men, fellow women, fellow men. So I would say to you, as a trial lawyer of 53 years now, that I'm a defense lawyer, but even as a plaintiff's lawyer, I would say to you that those chances are, Karen, that those cases, if they exist at all, would be few and far between because of the heroic measures. And everyone understands, or should understand, or will understand, if that ever would come to a courtroom, about the emergency efforts made by healthcare providers to save lives. I wouldn't spend time worrying about that type of thing, Karen. I really wouldn't. I think the world knows about the heroic men and women of healthcare. But if there is a case here and there, there are very, very capable defense lawyers that would step in, and I'm sure very aggressively and successfully defend you. Does that answer your question, Karen? Karen? Okay.
Yes, it does. But I'm sorry, I'm still going to see the, like I do here in Cleveland.
Their foot. You can never read their hieroglyphics. Of course, today we have the electronic medical record, which makes a big difference. But the key is, as I said in my remarks, you have to have a clear treatment plan. You have to have evidence that the doctor or the healthcare provider has made a diagnosis, exercised the differential diagnosis, made a decision, implementing the plan, and there has to be documentation that those events along the way are documented. If there are holes in the medical chart, then the lawyer on the other side can fill in those holes with expert witnesses who say, hey, if it's not in the chart, it wasn't done. I mean, we've heard that. I've heard that so many times I want to throw something at the witness. But charting is, I know it's time consuming, but it is so important. Now, the electronic medical record has been certainly much more positive than when doctors used to write their progress notes in hieroglyphics. I mean, I've had a couple of trials where the other side put the doctor's notes up on a big screen and said, doctor, come up to the screen and tell us what your notes say. And the doctor looks at the notes and he can't read his own writing. And that's embarrassing as hell and doesn't really sit well for trying to defend the fellow. Legible, unaltered, untampered with notations are very, very, very important. And so if there's a clear path from diagnosis to implementation of care, treatment, and medical management, the chances are it's a shield and not a sword.
Okay. I think we have time for just a couple more. Someone asked if you could share your journey of how you became a malpractice lawyer.
Well, I went to Ohio State Law School. Even in high school, I was interested in medicine. I was interested in, so I went on to Miami of Ohio, where I took business courses, but I did take my electives in anatomy, physiology, and so on. And then went to law school, always wanted to be a trial lawyer. Took as many courses as I could in law school, but you don't get that many in trial work. I was fortunate to be hired by a large firm in Toledo, Shoemaker, Loop and Kendrick, where I was trained by probably 3 of the top trial lawyers that our community has ever seen. I was very fortunate to have the tutoring by some outstanding trial lawyers. And since I started practicing in the late 60s, when the medical malpractice crisis began to bloom, I was asked by these 3 trial lawyers that I was sort of interning with in the law firm and being trained by. They said, we're going to be branching out into this area. Would you be interested in learning, working in this area? I said, yes. They said, the bad news is you got to learn medicine. The Medical College of Ohio, now UTMC, was beginning to take place, was beginning its presence in Toledo. I went out there and met with some of the doctors and sort of begged them to tutor me and to coach me in medicine. And lo and behold, not only did they do that, they sort of took me under their wing and trained me, and then suggested that I go in to scrub into surgeries. And so I spent many hours in my career scrubbing into surgeries with surgeons of all different types to learn medicine real time, not only from the books, but in actuality. I was very privileged to stand by some outstanding surgeons in all different types of specialties. And so it became a specialty. I became a specialist in birth trauma cases because they were the highest exposure. So the insurance companies I represented wanted me involved in those. So it was a wonderful career. I'm now teaching and I love teaching, but I certainly look back at my 50+ year career in the courtroom and say I wouldn't trade it for anything. Great career, privileged to have been associated with many, many great lawyers.
That's wonderful, Jim. There were a few other questions that I don't know we'll have time to get to today, but I will email them over to you, Jim, and maybe we can get those addressed and we can send them out for future.
That would be fun.
For future
Amanda,
reference.
thank you for inviting me today. And
yes, we appreciate it so much that you've been able to share.
And watching, we have a terrific health and human services college here. We're probably the only college that has a courtroom that is not in a law school. We train our students in this courtroom in our paralegal and pre-law track studies. So come and visit us. We've got great professors and it's a great college. Dean Merrick has been our dean now for a year, terrific leader. So we're very blessed and we'd be glad to serve anyone that would like to visit us at the University of Toledo. Thank you again, Amanda, for your time.
No problem. And thank you everyone for joining us today. We really appreciate you taking the time out of your busy schedules to help engage in this interesting topic. So hopefully our future events will be in person and maybe we could do a tour of that courtroom or something in the future. That would be really fun to get us back on campus as some of these restrictions start to lift. So again, thank you all so much. We are so proud that you are all alums and we hope you all have a great rest of your day. Bye.